So just a little bit about me really quickly. I have a lot of experience supporting families with, estate planning and estate settlement. And I have some professional designations, of course, that qualify me to do that. And I think, the key piece that my approach, my goal is to always make these topics more approachable, more easily digestible. I know and I understand these are not fun topics, but they are important topics, and we really want to help you to deal with this stuff that you probably don't deal with every day, right? Now, unfortunately, not only do I have professional experience and help people with this professionally, but I have also been there myself. I know firsthand how overwhelming grief can be. In recent years, I lost one of my oldest and dearest friends, followed shortly afterward by my dad, quite unexpectedly, and several other family members and friends. So I just want to express that I understand that when you add to grief the immense challenges of navigating an estate settlement, which is typically unfamiliar territory for most, it's no wonder that so often things don't go smoothly. So when someone passes, it often brings up issues that need to be handled delicately. I try to do that and prioritize that absolutely. I do feel like clear explanations goes a long way in this, and that's what I'm trying to do for you today. ClearEstate, our goal is to provide people with peace of mind and essentially help set everyone up for success. I did have one client who told me that it's a graceful and kind exit having a well-prepared estate plan, isn't it? And I just thought that that was such uh, a just spot on, way of looking at it. And that's essentially what we're setting out to help families do. In terms of, clear estate, and sorry, my mouse is like just kind of wild here. What we do and how we do it. So this is Alex Gauthier. He is the co-founder and chief product officer at Clear Estate. And a few years ago, he was faced with the passing of his mom, and he was tasked with the challenging duty of being her executor. And he had to overcome many obstacles and antiquated processes in order to get things done. And he really did experience firsthand the absence of a sort of end-to-end service that truly supports executors throughout the entire estate settlement process. And as a result, he kind of felt a deep calling. So he put on his product hat and he formulated his own solution, essentially. That was how Clear Estate was born, right? He was joined by our co-founders, and together they assembled a team of dedicated engineers and subject matter experts who shared the mission and vision and wanted to get this right for people. So essentially, ClearEstate is a one-stop shop for estate planning and settlement. We combine our advanced technology for high efficiency and an expert team to simplify matters for the families we support. And ultimately, we're changing the way estates are settled. Our goal is always to provide the right amount of support needed and desired for the particular situation. We try to demystify the whole process and provide clear next steps, a clear process, and clear guidance. We really have broken down the tasks involved in such a way that we can efficiently support the process, saving families time, money, and strain, and ultimately protecting their intentions and their loved ones. So in terms of today's session and the learning outcomes, what we really want to do for you today is, no matter what brought you to join us, perhaps you're currently facing the daunting task of settling an estate, in which case I'm terribly sorry for your loss. And I hope today helps you feel less overwhelmed. You may be expecting to act as an executor someday, in which case I hope that doesn't happen for a long time, but that today helps you prepare for that important role. You may be considering your own estate plan, in which case I hope this helps you feel confident to make the important decisions that are involved. And we really want you to come away from this session with some knowledge as to how to effectively manage an estate, be aware of some of the common pitfalls and how to avoid them, as well as know where to go for help. Okay. One thing I will note here is that there are at times significant jurisdictional differences between estate laws and processes. So today we are speaking a little bit generally, as we of course have attendees from all over. However, I'm going to cover common elements and general principles and perhaps mention a few jurisdictions. Okay. Now, number one, the first thing you need to know as a first-time executor is what actually is the executor's role. Okay, and you'll see there's quite a bit listed here, but truthfully, this is really just an overview of the executor's role. I cannot underscore enough how important it is to understand the duties and responsibilities of an executor and the importance of choosing this party wisely when you're building your own estate plan. Okay, so essentially an executor it's a fiduciary role, which means you're responsible to others. Okay. And one thing you should be aware of there too is that typically an executor cannot be forced to act in this capacity. So if you're not comfortable with it, or if you're planning who your own executor is going to be, they really should agree to it. And if you're not comfortable with it, providing you don't start engaging in the executor duties, you can't be forced to. Okay, so that's important to keep in mind. You should also always act reasonably, prudently, and impartially. And essentially what that means is, if your actions were to be scrutinized, would a neutral third party of average knowledge and awareness be in agreement with your actions? Okay. And sometimes that can be a gray area, but generally speaking, you're expected to act in a manner that makes sense. Okay. You need to follow applicable jurisdictional statutes and be aware of this. And like I said, this does vary by jurisdiction, sometimes significantly, but generally speaking, your powers you do have limitations to your powers, and unless there's a document like a will that gives you, specific additional powers, there are some limitations in what you can do. For example, you can't redirect how an asset is going to be distributed if there's specific legislation or instructions under a will, right? That would be something that you can't necessarily do. Okay. You need to fully, understand those powers and limitations, and ultimately know what you're expected to do. Okay. You have a duty to preserve and collect estate assets. Okay. So for example, if there's real estate or personal effects, you would want to know, are they physically secured, right? Is there locks on the home? Who has access to it? Is there adequate insurance in place? All those little details that you have to think about, because it's a responsibility and it's a liability, right? To care for and maintain these assets. Okay. You also, some people don't realize that when it comes to investments, if the deceased had certain investments set up, you'd need to carefully review those and understand whether or not they continue to be appropriate, because they may have been appropriate for the person who's making the decision and has a sort of risk tolerance involved, but the executor duty is a little bit different. Your main, responsibility is not necessarily to earn income in the estate through, high risk investments. It's more to preserve and protect the estate. So you'd want to review that carefully to make sure that there's, any assets that might be volatile or risky, that you're aware of that and you take steps to deal with it if it's appropriate to do so. And obviously in keeping with instructions that may be under the will. Okay. In terms of collecting the estate assets, of course, that's your responsibility to do. And we'll talk a little bit more in the next slide regarding the process involved in doing that and how you actually collect the estate assets. You have a bit of a duty to maximize the value of the estate. I mentioned just now that, earning income is not necessarily a priority. However, it is expected that you will be careful to not spend or waste estate resources and assets unnecessarily, okay? And definitely seeking advice and incurring expenses is typical. However, doing that with sort of reckless abandon, is not necessarily reasonable, okay? When it comes to settling debts, this is very, very important. You are expected to review and confirm the validity of any estate debts, right? Not just incurred after death and in the estate, but anything that was owing prior to death, okay? And you're expected to settle these and from the estate assets before distributing the estate ultimately to the beneficiaries. Okay. One thing I want to mention here too is that you are an executor is entitled to compensation. What that looks like depends on a number of things. Sometimes a person can indicate in their will how they want an executor to be compensated. I would say that would be ideal. Some jurisdictions have specific rules around compensation. Typically, an executor can choose not to take compensation. However, if they do, many jurisdictions, the guideline is 5%. In some places, there is a mandated amount that is considered appropriate for executor compensation. Just depends where you are, but it is important to be aware of because this is potentially an expense in the estate and something an executor may want to consider carefully. They may at first think, oh yeah, I'm going to take on these duties and I don't expect compensation. However, realistically, acting as an executor, it's an important, role that carries a lot of responsibility and even liability with it, right? It also typically takes many hours, hundreds of hours to complete an estate settlement, start to finish. And of course, your time has a value as well. You also are expected to potentially, research and satisfy yourself as to the decisions you're making in the estate settlement. So, it's a big responsibility and comes with a lot of time and energy that you need to expend to get the things done. Okay. If, as I said before, if you have questions, please feel free to add them to the Q&A box, and we'll do our best to address them near the end. Okay, so number 2, this is also a little bit of a busy slide. The second thing that you need to know as a first-time executor is really how to settle an estate, right? What does that mean? What do I actually do in order to settle an estate? And here I've given you a really high-level overview of how I would break down a typical estate settlement into 3 main stages. Lots of different people may break them down in different ways. However, these are the main ways that you would actually, this is the main steps in the process. Okay. What you should know here is that on average, an estate settlement takes approximately 16 to 24 months. Lots of folks are surprised at that. It seems like a long time. However, when you break down what's involved and the steps that need to be taken, it can actually take more than that, but it, generally speaking, 16 to 18 months even is pretty typical. Okay. Now here I talk about the very first step as an executor is to assess the circumstances. So at this stage, you're basically collecting as much information as you possibly can about the deceased, their assets, their liabilities, and their family and beneficiaries, as well as understanding any immediate needs. So, are there ongoing bills that are being paid? Are there any, are there minors that need to be cared for, dependents? Is there anything that you need to address right away to make sure that, things are sort of safe, secure, and et cetera? Now, I mention here with and without a will because essentially, if a person has a will, then they've obviously, hopefully named an estate representative, the executor, and that already gives you a little bit of ability to start, collecting information and assessing things. Without a will, things do get a little bit more complicated. Essentially, without a will, there's no legal representative of the estate, and there's no automatic, in most jurisdictions, there's no automatic way for someone to be the executor. It's typically involves a process with the court where they become the estate representative. Okay, so I talk about this a lot on the estate planning side of things because I think lots of times people feel that their situation, is not complicated, and so they haven't really got around to making a will. But what really happens at the end of the day is that without a will, it's automatically complicated for your loved ones because they have to go through this process of actually appointing a representative of the estate with the court before they can proceed with anything, really. Okay, so that's really important. In terms of identifying and notifying, the parties that are involved and safeguarding assets, you're expected to do that, to the extent that it's possible. So of course, if there's credit cards, like where are they, who has access to them, if there's, bank accounts and online accesses, as well as identifying and notifying any third parties, the beneficiaries, of course, but also, you'd want to notify the government and creditors and things like that as well, obviously financial institutions, etc. The second stage of administer really is you need to confirm the value of all assets, and in some cases that's very straightforward, cash in a bank account, simple. In other cases it may require a little bit more research and possibly even an appraiser. For example, if it's real estate and you need to confirm a value of the real estate assets, that would be an important step is arranging appraisers. Sometimes there's collectibles and things like that. You may also want to engage an appraiser for that. Essentially, the executor is expected to confirm the value of all the estate assets. So typically you want to be able to produce proof of those values. Here I talk about filing for probate. I'm going to go into a little bit of detail on that in the next slide, but essentially that is often part of the process. And ultimately, once probate is done, if it's needed, then you're going to collect and typically liquidate the estate assets. I say typically because that's sort of the default, although, of course, sometimes there's specific instructions in a will that direct particular assets to go directly to a beneficiary. And you're going to ultimately settle estate debts and liabilities. And it's important to know that that's your first responsibility before reporting, the amounts that beneficiaries are receiving to them. So that's definitely an area where potential pitfall is that you've made a commitment to a certain amount and you didn't anticipate that there was X number of dollars still owing on a credit card or a mortgage, etc. So those are important things to sort of keep in mind and part of the process of administering an estate. The final stage here, of course, is to distribute the assets. So typically you would set up an estate bank account to compile all the assets, and then you would actually transfer assets. And here I talk about specific gifts, and that would be, I give my grand piano to my daughter, etc. Things like that, specific nature. Those would be gifted first. And then the estate residue is the balance of the estate after the debts are paid and the liabilities are cleared. The debts and liabilities are cleared and the specific gifts are distributed. And at this point, essentially, the balance of the estate residue, it's typically directed into shares, right? So a percentage, however that percentage looks like, and you would distribute it to the estate beneficiaries, okay? You also would obtain releases and clearances, which is very important as protection for the executor. So what that means is essentially you'd have the beneficiaries and oftentimes the government sign off on the completion of the estate accounting and that it's all been done correctly up to that point and everyone's comfortable and there's no further questioning of things. That's the executor's sort of protection that they've actually managed their duties carefully and prudently, and everybody understands their inheritance and the amount that it equals. Okay. Now the next topic is of course probate. This one definitely comes up a ton. And oftentimes there's a lot of sort of confusion around exactly what it is and why it's needed. So I'm just going to explain that. And it's definitely something that is important for an executor to understand. So probate is essentially a formal process where the estate representative is verifying their authority, typically with the court. Okay, so what it does involved in that process is producing the original will. And if there is no will, there's typically, it's still generally considered probate, but the steps are a little bit different. And you're verifying the assets of the estate, the liabilities of the estate, who the beneficiaries are, and the court would review it and stamp their sort of approval on it. And then that's your confirmation and proof positive of your authority to represent the estate. Now, in terms of when and why do you need probate, the question becomes, as the executor, when you go to deal with third parties who you're actually needing to deal with to settle the estate, what are they going to require of you? And it's their legal right, typically, to require that you produce this probate. So typically with financial institutions, because it provides them protection and assurance that they're dealing with the correct executor of the estate, this is why they ask for it, okay? In some circumstances where perhaps there are no assets forming part of the estate, you may not need probate. So that's why it becomes a question of, okay, what are the estate assets? And will the executor need to produce this proof in order to actually deal with those assets? Okay. Some examples of assets that may not actually may not form part of the estate are anything where you can designate a beneficiary, such as a government savings plan or a life insurance policy where you've named specific beneficiaries. Typically that won't form part of your estate and won't impact the probate process, okay? Also assets that you hold joint with a right of survivorship with others, in any type of asset like that. And it's important too to clarify that when you're planning for your estate settlement, you should always kind of be aware of that, what assets are going to form part of my estate and what assets are not going to form part of the estate. Okay, so it's important an executor to be aware of that, as well as if you're doing your own estate planning. Here, so definitely there's typically costs involved in filing for probate. Lots of jurisdictional differences there. Sometimes there's probate fees that are essentially paid to the government. In Ontario, for example, probate fees are 1.5% on the amount over 50,000. But in many other jurisdictions, it's different. And set out by legislation. Sometimes there are no probate fees actually, but there are other fees like court filing costs. So it really depends on the jurisdiction, and it's something that an executor should be aware of in order to properly understand the expenses of the estate. Okay. How long it takes, again, this varies greatly by jurisdiction. The process is a bit in the hands of the court and the court docket in terms of how busy they are. I'll say smaller jurisdictions tend to be a little bit faster than larger municipalities, but generally speaking, it can take anywhere from a few weeks to several months. So it does vary quite significantly. And where your executor has the best chance of doing that process quickly is obviously where they're sort of well informed as to your assets, because they require that information in order to be able to put the probate application together and proceed with probate. Okay, the fourth sort of most important thing you should know about being an executor, and really like this one is massive, because how to account to beneficiaries is probably the most significant way that an executor can dictate how smoothly the estate settlement is going to go. Okay, so obviously when an executor is accounting to others, sometimes it's their family members or friends, things can go sideways quite quickly. And in my experience, I've definitely seen this occur, unfortunately. Even in the best of cases, the best of relationships, everything is going smoothly, and then all of a sudden somebody is not sure why something in particular happened, and then at that point things go completely sideways, and it becomes a huge burden on the executor to actually deal with managing these relationships. So here I want to talk a little bit about ways that you can avoid that, because it's really important. But definitely it's up to the executor to hopefully sort of manage the relationship in such a way that you're set up for success. Okay, so the first thing is obviously be transparent. And that just basically means that you're going to have open lines of communication with the beneficiaries and be responsive to them, right? The second thing definitely is anticipate issues. Knowing what you know about the deceased, about the estate, about the family and the circumstances of the beneficiaries, think about what their concerns may be even before they raise them with you. This will help you to understand, are there options in dealing with a particular issue? Should you approach things one way versus another way? Do you need more sophisticated assistance? And things like that. In terms of this goes back, allowing for questions goes back to open lines of communication. Let them have a chance to digest things and then ask you questions. Proactively providing updates is an absolutely fantastic way to do that. And sometimes that's in the form of, a shared document, or it's really in the form of bi-weekly scheduled calls or something to that effect, whatever feels right and suits the situation. But the main thing is so that the beneficiaries feel that they are being accounted to. Okay. The other thing that's important is treat equal beneficiaries equally. And by that I mean, if they are if they're part of the same of what we sometimes call class of beneficiaries, then you really should be providing them all with the same access to information, the same level of time and energy in terms of dealing with them and accounting to them, because it's really important that you maintain your impartiality, and that you're able to show that you maintained impartiality. Okay. And the last thing here, of course, consider professional support. I know that at ClearEstate, we see immense value and immense impact in being able to account to beneficiaries clearly and transparently. We definitely recognize that as something that was really important right from early on. And so our platform actually has a feature where beneficiaries can log in and they can see the progress of an estate settlement. They can potentially ask questions to the executor, and it's all carefully documented and transparent. And that has definitely proven to be a significant way that that executors can set themselves up for success. Okay, so that's most certainly an important one. Now, the fifth thing, the last thing here, is how to get the right help. Okay, and I want to stress here too that you might not necessarily feel that you need help, and that's okay. But at the same time, these are typically topics that most people don't deal with every day. There may be things that you're not fully aware of the impact of certain things or how certain processes should work. And what I've seen happen, unfortunately, is people feel, of course, it's an honor to be appointed as an executor, absolutely. And the vast majority of people take that very seriously, and they want to fulfill their duties responsibly. And sometimes that means they, in some senses, may kind of bite off more than they can chew, in that they start to carry out the duties and they think that they're doing okay, and then at a certain point they kind of get in over their head, or they proceed with a certain course of action that perhaps is not advisable and get into trouble, right? And then in that case, it does become a little bit difficult to sort of correct the course of action that may have been taken. So it's really important that you consider getting help as an executor. And as I've outlined here, be really careful about going DIY, Googling things, and using that approach to feel confident in how you should proceed. And I will say too, like I mentioned here, be careful receiving advice from others, particularly non-professionals, because I had a case where someone said, "Oh, my neighbor, she administered her dad's estate, right, and everything was done in like 2 weeks." And I said, "Oh, okay, like that's pretty quick." And it turned out that she had gone ahead and done some things that were not actually meant to be done so quickly or without any thought of the consequences of those things, right? So I would say be careful with where you're getting advice from. Definitely consider professional expertise. And I will say about that subject matter experts preferred. So people who normally work in the realm of estate settlement, ideally, because of course, not all professionals are created equally, and it is important that you have the right expertise. And I mentioned here too, you want to understand the service you're getting, and what options that are available to you, as well as the costs of engaging a professional in advance. And one assumption that I want to clarify here too is that you don't necessarily need a lawyer to settle an estate. You don't necessarily need an accountant either. It really depends on the specific circumstances. And that being said, like I've stressed, a lot of the processes are potentially challenging to go through on your own. And in many jurisdictions, the court forms in particular are not easy to navigate and complete. So that is something that you may want professional guidance with. And I will say that, ClearEstate is really doing things a little bit differently. Typically, the more traditional service providers like law firms and trust companies, they do provide support with estate settlement. but it's not necessarily complete support in that, a law firm typically focuses very much so on the court process and the legal process. They don't often provide a lot of guidance and explanations, or if they do, that's typically at a potentially excessive cost, an hourly rate that gets added on. Sometimes that hourly rate is anywhere from $500 to $1,000 an hour. So it's important that you understand the services you're getting, what exactly they're going to help you with. So, for example, ClearEstate offers us all of our packages for estate settlement comes with a dedicated estate professional that's going to actually support you through the entire process, not only the court application required, but also actually all the steps involved, all the notifications, all of the various things that you need to do. And how you choose to engage our packages depends on the level of complexity and the amount of support that you desire. So our goal is to empower you to do the duties in a way that you're comfortable with. Law firms and trust companies typically don't offer such a robust type of service. So it's just something that this is what we talk about when we say we're changing the way estates are settled. That is ultimately what we're trying to accomplish. So we have covered the 5 topics. We're going to do a quick key takeaways, cover the key takeaways, and then we're going to open it up to some questions after that. Okay, so if you do have questions, please feel free to go ahead and add that into the question box. Okay, so again, key takeaways is an executor needs to understand their duties as well as the estate settlement process, and of course that would be specific to your particular circumstances, the particular facts of the estate, right? You need to absolutely communicate transparently with beneficiaries. And I would say if any of you in here are thinking about your own estate planning, that's equally important in the estate plan, is to the extent possible, include your family members in discussions around the plan, because that will help set them up for success in accepting your intentions. Okay, and of course the final thing is seek guidance from subject matter experts who will help you in your role and provide you with the support that you need. Okay, now ClearEstate does offer free, no obligation consultations. Some of you here may have had one already. If you haven't, you're welcome to book. Alif is going to put up a link in the chat so that you can book directly if you wish. Happy to have you do that. You'll basically be able to talk to an estate solutions advisor who can provide you with more information based on your unique situation and how ClearEstate may be able to help you. And like I said, we do that on the estate settlement side, of course, as well as on the estate planning side. So happy to have you book a link. You'll also get it afterwards in an email to book that way as well. Okay, so now we're going to jump right in to any questions that anyone has. And I think, Alif, you're going to help me. Perfect.
We have a lot of questions. So a lot of great questions, actually. And I'm really glad you're here, Sara, to answer these questions. So I'll go in order. And just heads up, guys, so you will be getting the recording. So let's say you have to jump off in the next 5 minutes or so. You can always watch the recording. We'll answer your question in the recording. So you always have that prepared for you. So just jump right into questions, Sara. So my first question I have here is, a law firm I have never worked with wrote the will, which names me as the executor for a person who is in palliative care. I have a copy of the will, but the law firm has the original. How do I get the original from them?
Okay, that is a great question. So the law firm will have their own protocols for when to release the original will, and it may not be until the time of your friend or family member's passing. you would just contact them and, let them know. In advance of that, it's, they're under contract basically with their client to safeguard the will. Okay. Yeah.
Going to the next question. How do you probate? Do you go to court, send an email? Can you please explain in a high level?
Sure. Yeah. So that one's a bit tricky because there's so many differences between jurisdictions. But generally speaking, most jurisdictions have a simplified process for smaller estates versus a full robust process for larger estates. And the threshold is kind of all over the place. In some jurisdictions, 25,000 and under is considered a small estate. In some jurisdictions, it's 100, and California, for example, is 166,000. So it just depends on the jurisdiction, and the process involves, in some cases, swearing to an affidavit. Typically, that's a notarial, a notarial witness signature. And then the application, the complete original application gets submitted to the court. Some jurisdictions allow virtual witnessing, and some applications can actually be submitted via email. So it just depends on the jurisdiction and how sort of far along they are in terms of the ways they accept a court application like that.
Thanks, Sarah. Going to the next question, can you please explain ex parte?
I'm not sure the context of that one. Let me take that one offline, perhaps, and we can talk about it. Yeah, for sure.
Awesome. And for the person who asked that question, feel free to book a consultation. You can speak with one of our teams to get specific tailored advice. So feel free to go that route as well.
Yeah.
Next question, wouldn't you just sell the investments once the person is deceased?
Great question.
Yeah.
Great question. So this actually comes back to, of course, my comments around safeguarding the assets and making sure investments, etc. So in many cases, because you actually need probate, yes, it would be absolutely something you would do, is just sell all the investments and move them to cash. In fact, that's the safest thing to do, right? In some cases, as an executor, you may decide that, perhaps it's very low risk, the investments, or depending on what the investment vehicle is, maybe there's penalties and you want to wait for a certain term to expire, and things like that. So you could potentially have some flexibility. Also, oftentimes financial institutions will not accept your instructions until you actually have probate. So then there could be a waiting period there where there's investments that are potentially volatile, and you may want to attempt to deal with them even in advance of probate. So that would be, it would depend on the circumstances, but certainly you'd be within your duties to sell the assets, but in some cases you may not, or may not be able to. Yeah.
And going into my next question for you, for a joint account with 3 people and 1 passes away, is this account still active for the other 2 people in the joint account? Also, will auto payment from this account remain in effect if money is still owned?
Okay, sorry, can you repeat that one again?
Yeah, for sure. For a joint account with 3 people and 1 passes away, is this account still active for the other 2 people in the joint account? Also, will auto payments from this account remain in effect if money is still owed?
Right. Okay, so this is a fantastic question. I'm really glad somebody raised this, because issues arise with joint accounts all the time in estate settlements. So the first thing is, it depends on how the account was set up and whether there's clear intentions as to, is it a joint with right of survivorship type of structure, in which case, if somebody dies, one of the owners dies, then the other remaining owners now essentially own the full account. Okay. Or is it a joint, is it a tenancy, is it tenants in common type of circumstance, where there's actually each person owns their share of that account, and the intention is not that it's joint after someone passes away. So unfortunately, not all financial institutions document this carefully, which is why when we're doing planning with folks, this is definitely something that we encourage people to carefully address. In certain jurisdictions, the presumption between spouses is clear. It's if there's, in the absence of evidence to the contrary, a joint account is intended to be joint with right of survivorship between spouses. However, between a parent and an adult child, in some jurisdictions, the opposite logic is applied. That where an account is joint between a parent and an adult child, the assumption is that it's joint for convenience and still owned by the parent, right? Which commonly occurs when a child is helping their parent to pay bills, etc., in their account. So then it becomes a question of, if the intention is for the child to actually receive that account, was that clearly documented? And if not, you can face problems when you go to the financial institution to deal with it.
Got it. Perfect. Perfect. Going to my next question. Can you explain what is a bond for? Does it protect the estate or me or the executor? Context around that.
Great question. So a bond is essentially where an executor, in this context, a bond is the executor is having a third party basically provide assurance that the executor is going to be, I'll say, good for it, right? So it's a way for and what it's designed to do is actually protect the estate beneficiaries and creditors. So it not in not all circumstances would require a bond. In some cases, the bond requirement can be waived. In some cases, it's only required if there is an out of the jurisdiction executor. But essentially, the question becomes, what reassurance do the interested parties, the beneficiaries and the creditors, have that the executor is going to go through the probate process, but then actually complete their duties responsibly and ultimately pay the creditors and distribute the assets to the beneficiaries? So that's the purpose of the bond. It's designed to protect the estate interested parties. Okay.
That's good. Awesome. Next question. How long has ClearEstate been around? Is it affiliated with any financial institution, such as a bank? And where is ClearEstate based?
Yeah, great question. Great question. So ClearEstate was founded in 2020. And in that time, of course, we've sort of grown to cover many jurisdictions. We were founded in Montreal, and we now are supporting multiple jurisdictions across North America, out of several different locations. I myself am in Toronto, and we have staff in several jurisdictions as well. And in terms of affiliations, so ClearEstate is backed by a number of different well-known Canadian institutions, including Torstar and Power Corporation. In terms of banks, National Bank is also affiliated, however, only from an investment perspective, where they're not involved in our operations. Okay.
Sounds good. And just heads up, everyone, we're getting a lot of great questions, and considering the timing, there might be a possibility we won't be able to get to your question. So again, I'll put the link to our consultation so you can get tailored advice for what you're looking for. And also, I'm also getting a lot of questions that are very specific about your key situation, which you might need a little more handholding or tailored advice for. So again, those type of questions I feel would be best to get one-on-one attention through a consultation. So again, link in the chat for that. Going to my next question, Sarah, can the compensation for executor be combined with a gift or more money for the executor?
Great question. So you can definitely separate those two things. What some people will do is they'll say, I give my executor X amount of dollars in lieu of executor compensation, and then it's truly treated as a gift. and or that you specifically do not expect the executor to take compensation because they're receiving X share of the estate. So there's a number of different ways you can do it depending on your intentions.
How do you pay the debts? Do you need access to checking accounts?
Yeah. So typically you would set up an estate account. Oftentimes you do need probate, like I said, to actually do that and collect the assets into the estate account. From there, it's you generally want to keep the accounting very clean, right? And not, commingle it with your own accounts or anything like that. And so an estate account is typically needed to deposit checks that are going to be in the estate of, et cetera, or transfer assets into, because the parties that are transferring the funds expect it to go to the estate of. So normally you'd open a bank account and settle the debts from there.
Got it. Perfect. Is 5% the guideline for payment to an executor?
5% in most jurisdictions is generally accepted as the appropriate amount of executor compensation. So, for example, if there's no mention of compensation and an executor carries out their duties, they would typically want actually the beneficiaries to agree to it. However, if it's within the 5%, the court would generally approve it with not much questioning. They could actually seek further compensation if the estate was complex or required additional time and effort for them to administer it more so than typically.
Got it. Perfect. For joint
so
property,
many questions. I love it.
yeah, guys, these are such great questions. You should see the chat right now, the Q&A box.
Yeah.
Wow. So going to the next question, for joint property, if one dies, does the property automatically belong to the other name on the title?
This goes back to the similar question around joint bank accounts. It depends. Is it joint tenants, which implies a right of survivorship, or is it tenants in common, in which case each owner owns their respective share of the property? So that's what matters in terms of how the title is held. If it's tenants in common, then technically the respective share of the deceased is an asset of the estate.
Got it. Perfect. Let's do the last few questions. I know we're running a little short on time. What are our fees like? Ball figure parks are okay. I'm assuming they're talking about ClearEstate and our offerings.
Yeah, so our estate settlement packages, they're available on our website, but I can tell you that the services, the packages range from $2,500 to $6,500. Depending on, again, the complexities involved and the amount of support that you desire. And of course, as we've said, you're welcome to book a free consultation to explore in more detail the specific circumstances and what package might be right.
And is that a flat fee, or is there like a?
Yeah, it's a flat fee. That we don't charge any additional sort of hourly rates or anything like that, which is exactly what we're setting out to do, is make these services accessible for people. And we support the entire process, including court applications and even tax returns where that's selected as part of the services.
Sounds good. And I do want to be mindful of time and for everyone who joined this presentation. I still have a lot of great questions here in the Q&A. So for folks who didn't get your question answered, I'd highly recommend maybe you book a consultation. Again, just so you can speak one-on-one. A lot of the questions I'm getting are very specific questions that are specific to your situation, which I don't think a general answer would really be the most effective. So again, I put the link in the consultation below. And I apologize if I wasn't able to if we weren't able to get to your question, but we want to be there for you. And if anything, you can also email Sara through the email that you received to join this webinar and everything. But Sara, thank you so much for taking the time to do the question and answer period.
Absolutely. My pleasure. Thanks everyone for joining us.